Ladies and gentlemen, welcome to the National Constitution Center and to today's convening of America's Town Hall. I am Jeffrey Rosen, the president and CEO of this wonderful institution. Let us inspire ourselves for the learning ahead by reciting together the National Constitution Center's mission statement. Here we go. The National Constitution Center is the only institution in America chartered by Congress to increase awareness and understanding of the U.S. Constitution among the American people on a nonpartisan basis. I'm so thrilled that this is the 9th year that we are co-hosting this great Supreme Court review with our partners at the ADL. It's such a meaningful event, so great that we can do it. As Fred Lawrence said before we started, we will repeat once again next year in Philadelphia. We hope we'll be able to reconvene in person. But until then, it's so meaningful to be able to bring together this magnificent audience of thousands of lifelong learners by Zoom. So you've been all engaging with the NCC. Make sure to check out our town hall programs that are all archived on the Interactive Constitution, our phenomenal We the People podcasts, live at the NCC, where we post the audio feeds of all these great programs, as well as our live Constitution 101 classes offered for learners of all ages. It's so meaningful to be able to teach them and to offer them to you online. We have America's greatest thinkers about the Supreme Court and America's greatest moderator of Supreme Court conversations, Dahlia Lithwick. And to introduce all of them, I will pass the mic over to Karen Levitt, the National Civil Rights Counsel of the ADL, who will provide a few remarks and then hand it over to Dahlia. Over to you, Karen.
So, hi, welcome to the Anti-Defamation League's 22nd Annual Supreme Court Review. Thanks, Jeff. I'm Karen Levitt, ADL's National Civil Rights Counsel. My pronouns are she and her. As in past years, the program is presented jointly with the National Constitution Center, and I especially want to thank our incredible partners there, Jeffrey Rosen, Tanea Tauber, Marissa Blum, and John Guerra. And before we hear from our distinguished panelists, I want to recognize ADL's Vice President of Civil Rights, Steve Freeman, our SVP of Policy, Eileen Hirschnov, our National Civil Rights Chair, John Harris, our Vice Chair, Ivy Kagan-Bierman, and our Legal Affairs Chair, Joe Berman. Today also would not have been possible without the support and teamwork of my colleagues at ADL. If you are seeking continuing legal education credit, I know this is the big question. Please be aware that CLE will be issued based on verified attendance, which includes both documenting the CLE codes on your evaluation form and being logged into the Zoom presentation. Due to overwhelming response, some of you may have been redirected from Zoom to YouTube or the event website, and regrettably, we will not be able to issue CLE credit for you. Our apologies. As for the codes, you should have received an email with CLE instructions ahead of time, including a link to an evaluation form. If needed, you can email cle@adl.org to request it. During the program, our moderator, Dahlia, will say the CLE codes, which will also be temporarily available in the Q&A and chat sections. Please be sure to make a note of these codes. After the program, email your completed forms, including the CLE codes, to cle@adl.org. The deadline to submit the form is July 31st, 2021. Because of the enthusiastic response we've received to this event, we anticipate that it will take 8 to 10 weeks to process your credit request, and we appreciate your patience. We have set aside time for questions. Simply submit them via the Q&A feature in Zoom at any point. And for those of you watching on YouTube or the event website, please accept our apologies that you won't be able to submit questions. If you are unfamiliar with ADL's work, ADL was founded in 1913 with the mission to stop the defamation of the Jewish people and to secure justice and fair treatment to all. We filed amicus briefs in many of the key cases you will hear about today. Links to those briefs are included in the materials for this program, available on ADL's event website, along with bios of our phenomenal speakers. Let me introduce them now. Erwin Chemerinsky is the current Dean of Berkeley Law. He frequently argues appellate cases, including in front of the US Supreme Court. Frederick M. Lawrence is the 10th Secretary and CEO of the Phi Beta Kappa Society and a distinguished lecturer at Georgetown. He is author of Punishing Hate. Bias Crimes Under American Law. Melissa Murray is a professor at NYU School of Law, where she teaches constitutional law, family law, criminal law, and reproductive rights and justice. She serves as a legal analyst for MSNBC and is a co-host of Strict Scrutiny, a fascinating podcast about the Supreme Court. Paul Clement is a partner at Kirkland & Ellis LLP and a distinguished lecturer at Georgetown. He served as the 43rd Solicitor General of the United States under President George W. Bush. And finally, our moderator. Dahlia Lithwick is a senior editor at Slate, where she covers the Supreme Court and jurisprudence and hosts the amazing podcast Amicus. She has either met or interviewed all 4 of the women who have sat on the Supreme Court. Dahlia, the stage is yours.
Thank you so much, Karen. And I want to, before we start, just add my voice to the deep gratitude both to Karen, Steve, and the team at ADL, and to Jeff and his amazing team at the National Constitution Center. It is so destabilizing on the one hand to do this on Zoom, inclusive and wonderful on the other hand to do this on Zoom. We want to thank everybody who has tuned in today. And I'm just going to say there's an immense amount of terrain to cover, and we always gallop through it. So please put your questions in the Q&A, and Karen will get to them at the end. We promise we'll cover as many of them as we can. With that said, I guess I will just give my tiny precatory overview before I turn it over to Erwin to give the masterful, comprehensive overview. And that is simply to say, we saw a huge change at the court this term with the death of Justice Ginsburg, the elevation of Amy Coney Barrett. And as a consequence, with the term winding down in the last week, you probably heard one of several narratives. Either you heard the media saying this was a 6-3 supermajority conservative juggernaut at the term, or you heard this was an incredibly moderate, temperate, humble term with a big concentration of centrist jurists at the middle of the court. Or you heard that this was a conservative court that wasn't conservative enough. So one of those narratives has to be true. And helpfully, we have some of the smartest people in the country to help us think through which of those narratives is true, or if they're all true, or none of them are true, or if we're just in the middle of one of those Rorschach terms that make it very confounding to say what happened. So that said, I turn it to Erwin to give us his kind of table setting, lay of the land, contours of the term, what happened, and what we can conclude from these past weeks. Erwin, over to you.
Thank you, Dahlia. It's such an honor and pleasure to be part of this again, to be part of this terrific panel. As Dahlia just said, the most important change in the Supreme Court in the last year was due to the death of Justice Ruth Bader Ginsburg on Friday, September 18th, and the confirmation and swearing in of Amy Coney Barrett on Monday, October 26th. It's been often remarked that every time there's a new justice, it's a different court. It's especially so when you've replaced a very liberal justice with a very conservative justice. I think we should think of this term, most of all, as a Supreme Court in transition. I neither want to overstate the importance of Barrett replacing Ginsburg, nor underestimate its importance. I think a statistic from last term is particularly revealing. A year ago, in October term 2019, the Supreme Court decided 53 cases with signed opinions after briefing and oral argument. By the way, that's the fewest number of cases decided in a year since 1862. Last year, there were 14 5-4 decisions of those 53 cases. In 10 of the 14, the majority was Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. All we know about Justice Barrett, from her writings as a law professor, from her time on the United States Court of Appeals in the Seventh Circuit, and from her opinions this year on the Supreme Court, is that she's quite conservative. So replacing Ginsburg with Barrett in those cases last year likely to change the margin, but not the outcome. They likely to end 6-3 rather than 5-4 decisions. But there were 2 decisions of the 14 5-4 rulings a year ago, where the majority was Roberts, Ginsburg, Breyerson, and Kagan. They were important cases. One struck down a Louisiana law imposing restrictions on abortion. The other said that President Trump could not rescind DACA, the Deferred Action of Child Arrival program. In all likelihood, those cases would have come out differently with Barrett rather than Ginsburg being on the court. I look at last year's statistics and on the basis of them would predict two things about this term. One is we will see more 6-3 decisions. There are 6 conservative justices appointed by Republican presidents, 3 liberal justices appointed by Democratic presidents. Second, we're likely to see fewer 5-4 decisions where the liberals are in the majority. Simple arithmetic explains this. The liberal justices would now have to get 2 votes rather than just 1, and they need to get 2 from a court that has 5 staunch conservatives in Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, and 1 moderate conservative in Roberts. And those predictions came true this year. It's exactly what we saw. The court decided 54 cases with signed opinions after briefing and oral argument. That's notable because the second fewest number decided in a year since 1862. Only last year was less. But a year ago, the court had canceled some oral arguments and put cases over to October of 2020. The 54 cases this year is really remarkable. Of those 54 cases, 12 were 6-3 decisions and 6 were 5-4 decisions. Also, there was no 5-4 decision this year that was ideologically divided where the liberals were in the majority. So if you want to answer Dahlia's question about was it a conservative or a liberal court, at least in the divided cases, the conservatives prevailed without exception. Few other thoughts by way of overview to the term. First, no longer is John Roberts the ideological median justice on the court. A year ago, when we talked about the Supreme Court, we could say it was truly the Roberts Court. We always name it after the chief, but also a year ago, there were 4 justices more conservative than Roberts, Thomas, Alito, Gorsuch, Kavanaugh, and 4 more liberal than Roberts, Ginsburg, Breyerson, and Kagan. That really put Roberts at the center. He was the swing justice. Is reflected in the fact that a year ago, he dissented only twice. He was in the majority in 97% of all the cases. But now there are 5 justices more conservative than Roberts: Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. This affects much of what the court does. Think of it in terms of granting of certiorari. It takes 4 votes to take a case. The 4 most conservative justices might have been reluctant to take certain cases if they were uncertain whether to have Roberts a 5th vote. But now they know they've likely got 5 conservative votes. And I think it will really change the agenda of the Supreme Court. I don't want to minimize the role of John Roberts. He's still the chief. He still assigns who writes the majority opinion when he's in the majority. But one interesting statistic this term, it was Brett Kavanaugh who was the justice most often in the majority, being there 97% of the time. Second, there was no pretense of judicial deference by the court this term. There was a time when judicial conservatism was about deference to elected officials. We didn't see that this year. In fact, as I went through the list of cases we're talking about, in almost every instance, the government lost, with the court repeatedly striking down federal and state statutes. I think it makes it a very different kind of conservatism and certainly has implications for what we're likely to see in the future. Finally, as we begin talking about this term, I want to provide my own caution against generalizing from a small sample. We all learned someplace in our education the risks of generalizing from a small sample. I was concerned by the generalizations that I saw in the media that Dahlia is referring to. After all, this is only one term of the Supreme Court. Justice Barrett didn't participate in the oral arguments in the October session, and so she participated in about 40 cases. And always some of those are not controversial at all. As we'll talk about at the end, I think it's next term when the Supreme Court's deciding cases about abortion, in gun rights, and maybe affirmative action, we have a much better sense of what the newly constituted Roberts Court is going to be like. That's why I said at the outset, I think the best think of this year is a term in transition.
Erwin, thank you so much. One of the most interesting aspects of the term happened, a lot of it happened in a set of orders and decisions that came down on the so-called shadow docket, which is to say these are cases that were not necessarily fully briefed or argued. They came down as a sequence of emergency orders around state and local government orders shutting down and imposing limits during COVID. I should note before I ask Paul to explain the COVID cases that the ADL brief that sided with the state shutdown orders, arguing that the free exercise clause never intended to require exemptions from public safety laws, that and the other ADL amicus briefs, and I'll reference them as we go along, but for much, much fuller exposition of what the ADL argued in those cases, please look at your materials. That said, I'm so delighted to call upon Paul. Both Paul, if you have 5 or 6 minutes, so if you want to reflect on what Erwin just said or what I just said, but also just asking you to help us understand what happened in these COVID shutdown cases, because I think, as I suggested, not only did it not fully get surfaced at the court, but I think it was not fully surfaced in the media either.
Thank you, Dahlia. That's a tall order for 6 minutes, but I'll give it a try. It probably, just to echo something Erwin said, it probably says a fair amount about this term that the first cases we're going to talk about are cases that were not merits cases, but were on the so-called shadow docket. And I think that underscores both that the main cases on what Supreme Court lawyers sometimes talk about as the plenary docket or the merits docket are not where all the action are. And also those cases on the main docket sometimes can be sleepier than the cases that are handled in these emergency orders. That was clear for much of the Trump administration, where the court was very active in these emergency orders, and it's very true of these COVID cases. So the arc of these COVID cases then also tells us a lot about the court in transition, because the first 2 efforts to get injunctive relief from an order of lower courts that left in place state restrictions, those first 2 efforts to get emergency relief were not successful. One of those arose out of California. The other arose out of Nevada. And the Nevada case is worth pausing on just for a second, because that was a case where arguably the claim of the people advancing the free exercise claim was maybe the strongest, because the state of Nevada, perhaps predictably, was putting greater restrictions on worship and attendance at church than on attendance at casinos. And from the perspective, I think, of some of the more conservative justices, that really put a real focus on the problem here, that a state was making different decisions when it came to commercial enterprises that were perhaps important for the long-term economic success of the state, and giving less preference and less preferential treatment to religious worship and attendance at church. But notwithstanding that favorable context for the parties pushing the free exercise claim, in those first cases, the court denied injunctive relief. And then just a few months later, in a series of cases, the court began to grant relief, and that was principally in cases coming out of New York and California. What changed in the interim? Well, I suppose 2 things. One thing that changed is that we did get a little bit more experience with the pandemic and a better sense of what kind of restrictions were really necessary. But I think the principal thing that changed was that Justice Barrett was confirmed and came onto the court and changed the composition of the court. And there were now 5 votes to essentially stop state efforts to treat religious exercise less favorably than other activities for purposes of these kinds of pandemic-related restrictions. And I think that probably more than almost any other case on the merits docket this term, these cases really show that the change in composition can have a dramatic effect on the results in the cases and the role of the Chief Justice. In the first two cases that I mentioned, the Chief Justice voted with the more liberal justices to deny relief and wrote in one of the opinions a separate writing that really explained his view that although he was quite sympathetic to the claims of the religious entities, and I think the rest of his jurisprudence on the free exercise clause bears that sympathy out, but notwithstanding that deep well of sympathy on the chief's part, he really thought that given the public health emergency, this was an issue that the courts should just stay out of. And then just a few months later, it's the Chief Justice in dissent in these orders, and it is a majority that doesn't need the Chief Justice any longer. And I think that's one thing that really does affect perhaps the future trajectory of the court, is not just the change in composition, but the idea that the court no longer will go as slowly or as quickly as John Roberts dictates in some of these important areas of the law. Just a word or two about what the court actually reasoned in these decisions. And these are all per curiam opinions, and exactly how much impact these decisions themselves will have outside of the COVID context, I think time will tell, but I think they give us a great snapshot of where the court is on issues like this. And what they really show is, at the threshold, a view of a majority of the court that the states and local governments and the federal government presumably really do need to treat religious exercise equally with secular activities. And in a sense, the tie goes to the religious activity. If you have a state that says that, for example, you can have no more than 50 people at religious services, no more than 25 people at a particular kind of commercial exercise, and no more than 100 people at a different kind of commercial enterprise. Essentially, the gist of all of these opinions is that's still discriminating against the religious worship. It doesn't matter that the state treated some non-religious activities the same or worse than the religious activity. If you can essentially point to one comparable non-religious activity that is subjected to better treatment, that's enough to get you into strict scrutiny. And the last thing I'll say about this, without stealing anyone's thunder, is one of the big decisions on this court's term was the Fulton case, where there was some sense that the court might overrule the Smith decision that had generally subjected religious laws to non-demanding scrutiny. And what you see in these COVID cases is that the trigger, even without overruling the Smith decision, the trigger for triggering strict scrutiny in these religious claims, I think, has become much easier to satisfy as a result of these COVID decisions.
So Fred, why don't you take a minute to respond to Paul on the COVID cases?
So two quick things. One, actually, I'll respond, Dahlia, to you and your challenge about which of these various configurations is at play. I think all of the above is probably the right answer. What's going to determine which one we're in? It's got something to do with the issues that are involved. The cases I'm going to be talking about later today include some unanimous opinions and near unanimous opinions. On the other hand, this shadow docket set of cases in the COVID cases really show us how the 5-4 operates, as Paul said. So what makes this one fall into the 5-4? One of the places I think it's fair to predict you're going to see the biggest impact of this growingly conservative court is in the area of religious freedom. This is clearly a major issue and part of the program for some of the most conservative justices. And so the articulation of this most favored nation status for religion really takes hold in the shadow doctrine. Likely you'll see that now go over to the merits doctrine in future cases. Other thing I would mention, and this was clearly mentioned in a very vigorous dissent by Justice Kagan, it's not just that the most favored nation status that the court is using that says if you do something for anyone else, you've got to do that for religion, that the court is also willing to say we're the ones who are going to say what's comparable and what's not comparable. So the case involving home worship, the state had said, we're treating all home activities the same, religious and non-religious, and the 5 justices of the court said, that's not the right comparison. We will look at outside the home and compare that with this restriction inside the home. So that's a very aggressive move to put religious freedom really as a first among among rights.
And it's also worth noting, I will say that in the statistics that Erwin shared at the beginning, it didn't include the shadow docket. And so I think I will pop in the chat in a minute, Professor Steve Vladeck, who I think ran the numbers, including all of the non-merits docket that Paul referenced, and maybe it'll give folks a sense of how the numbers shake out if you look at what was happening in some of these per curiam orders. Melissa, I want to turn to you, and I want to stay on this question of religious liberty. I feel like certainly as long as I've been doing this event at the Constitution Center, we've been having this conversation about what feels like the collision course between civil rights and public accommodation laws on the one hand, and claims of religious dissenters that they cannot be forced to do things that violate their own religious conscience. And as Paul intimated, Fulton was meant to be, I think we thought it was going to be the big bang where we figured out how the court thought about this. So I want to give you sort of ample time, 7 minutes, to talk about Fulton, and maybe at the end also you can talk about Grimm, and just maybe talk about where the court chose not to go, and help flesh out what I think Paul and Fred have really telegraphed is going to be an area that more and more and more is going to take up the court's time and ADL's time. I should note that ADL filed a brief in Fulton, siding with the city of Philadelphia. Again, please look at your materials to see details. But Melissa, can you kind of give your best shot at explaining what did and didn't happen in Fulton this year?
Sure. Thanks, Dahlia, and thanks so much for having me today. As Dahlia said, Fulton, it was one of the most watched cases on this term's docket, in part because it was expected to be a rather maximalist decision in favor of religious exercise. The court did not go all the way. It was asked to overrule a 1990 decision, Employment Division versus Smith. It declined to do so. But it wasn't a minimalist decision either. It was decided 9-0, written by the Chief Justice, but its unanimity, I think, can be characterized, as Dahlia put it, as a kind of phonymity. It's not a unanimous decision that is narrow. It does move the law in a more conservative direction, and again, toward this idea of religious freedom being a sort of favored nation place where this is a right that is preeminent among other kinds of civil rights. So the case took up where 2018's Masterpiece Cake Shop left off. It was supposed to decide this question of whether religious liberty trumps civil rights mandates. In the case, Catholic Social Services, which administered the foster care services for the city of Philadelphia, argued that it was entitled to an exemption from the city's non-discrimination policy, which prohibited discrimination on the basis of sexual orientation. The lower courts concluded that the anti-discrimination policy was a neutral law of general applicability, and under Employment Division versus Smith, it determined that the application of the non-discrimination policy to CSS did not constitute a violation of the Free Exercise Clause. CSS appealed that decision to the Supreme Court, and in so doing, asked the court to revisit and to overrule Employment Division versus Smith. In a unanimous decision written by the Chief Justice, the court held that the application of the non-discrimination policy did burden CSS's exercise of its religion because it required the organization to choose between curtailing its mission or approving relationships inconsistent with its beliefs. The question was whether or not the Constitution allowed the city to impose such a burden. And under Employment Division versus Smith, such a burden would be permissible because the law ostensibly would be a neutral law of general applicability. But the court in that unanimous decision held that Smith did not apply because the non-discrimination policy contained a system for granting exemptions. And in that system, there was discretion afforded to the decision maker. And so although the city had never granted an exemption from the non-discrimination policy, the possibility of being able to do so meant that the policy could not be considered a neutral law of general applicability, and Smith did not apply. So that sort of canny turn took the question of whether to overrule Smith off the table, foreclosing a more maximalist decision. But it nonetheless pushed the court to review this policy under strict scrutiny because Smith was not applicable. And under strict scrutiny, the court determined that the policy failed, that it was an impermissible burden on religion. So Catholic Social Services won, although it did not win quite as big as it could have. It's worth noting that although the court avoided that thornier question of whether to overrule its 1990 precedent in Employment Division versus Smith, there were 3 justices on the court who made very clear that they were certainly willing and perhaps even eager to take up the question of Smith's continued vitality. In a concurrence, Justice Amy Coney Barrett, who sided with the Chief Justice on this issue, nonetheless expressed some skepticism of Smith. And in a stinging concurrence that really read more like a dissent, Justice Alito made clear that he would have taken up the question of Smith. Related to this issue of LGBTQIA rights, the court declined to grant certiorari in another case, Gloucester County School Board versus Grimm, and that case presented the question of whether Title IX or the Equal Protection Clause of the Constitution requires schools to allow transgender students to use multi-user restrooms designated for the opposite biological sex. Because the court denied certiorari here, the Fourth Circuit's opinion, which held that the school district violated federal law when it barred students from using the restroom that aligned with their chosen gender identity, will stand. And so the denial of review was celebrated as a victory for LGBTQIA rights, but it does not foreclose the possibility that the court will in the future take up a similar issue related to transgender rights. So still a pretty unsettled landscape in terms of LGBTQIA rights, and certainly in the conflict between religious liberty and civil rights protections.
And Erwin, will you take a minute and just respond to what Melissa laid out?
I very much agree with Melissa's analysis. There's always a tension between liberty and equality. Any law that prohibits discrimination limits the freedom to discriminate. But the court has made the choice for well over half century that stopping discrimination is more important than protecting a freedom to discriminate. But now we have a majority of the Supreme Court that says that people, on account of their religion, can discriminate against others. The court says, as Melissa pointed out, that any law that has discretion that imposes a burden on religion must meet strict scrutiny. Most laws have some discretion. Doesn't matter, the court says, whether the discretion has ever been exercised. It doesn't matter whether there's ever been discrimination against religion. I think this largely undercuts the Smith decision, even though it leaves Smith on the books. We're going to see a lot of cases about this in the years to come. Employers, on account of their religion, claim a right to discriminate gay, lesbian, and transgender employees. Businesses that refuse to serve same-sex couples. And I think we have a majority that's going to protect such discrimination when it's on religious grounds.
Fred has the privilege and honor of getting to present the case that was certainly the most fun to cover this year. That is the case of the swearing cheerleader. It had such delicious facts. And before I ask Fred to lay out what happened, I want to point out again that ADL joined in a brief urging the court to ensure that when it comes to off-campus student speech, schools can certainly regulate student bullying, harassment, or threats, but not speech that is merely perceived to disrupt school activities. Again, in your materials, take it away, Fred, the case of the swearing cheerleader. And you're muted.
And I'm muted. How's that? She was not the swearing cheerleader, and that's what raised the what turns out to be one of the most significant campus free speech cases in years, arguably since the celebrated Tinker against Des Moines Independent Community School District case in 1969. Tinker, best known for the celebrated language that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. But of course, what Tinker also did is it gave schools the right, and it recognized a special interest of schools to regulate free speech and expression in certain instances, those instances, and I'm quoting here, that materially disrupt classwork or involve substantial disorder or invasion of the rights of others. So that's the background. Is Tinker going to apply here? And let's talk about what happened in it's not armbands the way to protests as it was in Tinker. This is a cheerleader who got knocked off or did not make the varsity cheerleading squad. So over the weekend and away from school, she posted a picture of herself on Snapchat with the caption of effing school, effing softball, effing cheer, effing everything. And for those of you who are wondering whether I was going to say effing or something else, you now know the answer. She, of course, did not use effing, but spelled it all the way out. After finding out about the post, school officials suspended her from the softball team for a year for violating school rules and team rules. She sued the school, claiming that the suspension violated her First Amendment rights. She won in both the district court and in the Court of Appeals, the Third Circuit. Third Circuit taking this up a higher notch and went much further than the district court. The district court granted summary judgment, citing Tinker and finding that her Snapchat post did not cause a substantial disruption at school, and therefore it reverts back to that protection not being shed at the schoolhouse gates. The Third Circuit affirmed the judgment, but held that Tinker, that part of Tinker that allows the regulation of expression, does not apply at all because schools are limited at the schoolhouse gate, and there's no special license for schools to regulate off-campus speech. Now, this, of course, raised a concern for many of us, and that's a big piece of the ADL brief here, because it would limit schools' ability to regulate cyberbullying, or other kinds of activity that takes place physically off campus, but has an impact on campus, including, for example, academic integrity issues. The court, in an 8-1 opinion authored by Justice Breyer, affirmed the holding for the student, but rejected the Third Circuit's approach, saying that while public schools do have a special interest in regulating some off-campus speech, the schools cited special interest in this case of promoting good manners, preventing disruption, were not sufficient to overcome the students' interest in free speech. The court said that a school's special interest in regulating on-campus speech does not always disappear when that speech physically takes place off campus, as it did here. However, there are 3 features that the court mentioned in particular with respect to this off-campus, physically off-campus speech or expression. First, off-campus speech normally falls within the purview of parents or family or guardians rather than the school to be regulating. Second, off-campus speech regulations could cover virtually everything that a student has the right to do or say. And finally, that the school has an interest in protecting a student's unpopular off-campus expression because the free marketplace of ideas is a cornerstone of a representation of our democracy, schools playing a major role in representation of our democracy. Using that framework, Justice Breyer said that her interest in free expression, the student's interest in free expression, outweighed the school's interest in regulating her speech here. The Snapchat post constituted criticism, in fact, directed towards the school, which would primarily fall within the scope of the First Amendment. It may not be the way in which most of us would express that criticism, but clearly it was her way, very poignantly, of making that criticism. The context of the speech, from her personal cell phone, off campus, and over the weekend, diminished the school's interest in punishing her and regulating her expression. Looking at the school's argument that it was promoting good manners and punishing vulgar speech, the court noted it's really parents and not the school who have the primary responsibility over weekend and away from school conduct. The post, although it was the subject of much discussion on school, really it was just for a few days. It clearly upset some students, but it did not cause, according to Justice Breyer, that kind of substantial disruption that was envisioned in Tinker. And finally, Justice Breyer answers the question we're all thinking, because it's hard not to describe this case in somewhat comical terms because of the nature of it. He says, no, but don't fall into that trap. He said it might be tempting to dismiss the plaintiff's words as unworthy of robust First Amendment protection, but sometimes it's necessary to protect the superfluous in order to preserve the necessary. There's only one dissent in this case. It's Justice Thomas, who takes the position that schools historically have had the authority to regulate off-campus speech, so long as it is an approximate tendency to harm the school. He felt that this fell into that category. He would have regulated it. Justice Breyer, writing for 8 justices on the court, took a different view.
And Paul, I'm going to give you 2 minutes to, if you can, help us understand whether Mahanoy, the speech case, created some rule going forward that we can apply, or if it was just a kind of one ride only, very, very interesting fun facts, but it's not clear going forward what the rule is in terms of student speech.
Yeah, Dahlia, and I'll say two things about the decision. The first, just to answer your question directly, I think that it's a little hard to discern a bright line rule from this majority opinion, but I think that's entirely intentional. And I think it reflects the fact that Justice Breyer was the author of the opinion. And, obviously a lot was said during this term on editorial pages and other places about whether Justice Breyer should step down. And obviously one of the things we're not talking about today is his retirement and his replacement or any of that. But this decision, I think, sort of shows Justice Breyer in kind of his full form. This is a classic Justice Breyer opinion. It is hard to imagine that any other member of the current court could have written this opinion in this way. The ability to identify the factors that are relevant, identify the countervailing factors, resolve them in this case without determining for all future cases which of the three factors that he identified as relevant is necessary or sufficient, is kind of classic common law judging and classic Justice Breyer. And I think almost in varying degrees, every other member of the current court is less comfortable with that kind of reasoning and that kind of judicial writing. And so I guess I will say that, whenever Justice Breyer decides to retire, this is something that I think the chief will miss, because I think, part of the reason Justice Breyer ended up with this case is because the chief thought that this case needed that kind of opinion, and Justice Breyer was the right person to deliver that kind of opinion. The only other thing I'll say very briefly is this case does underscore that these justices disagree on a lot of things, but they all agree that free speech is very important and should be robustly protected. This was not foreordained to be an 8-1 decision. And the fact that only one justice dissented does underscore this is a pro-free speech court.
I'm going to give out the first CLE code right now, and it's Marshall, 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 Marshall. I imagine that if they're like watching this Zoom from outer space, they have no idea what just happened, but we're popping it in the chat, and that is the first CLE code. This brings us to, I want to say, the most important case of the term, but I think for a lot of people it isn't, and I think that how you freight this case determines the answer to my opening question, which is, was this a 6-3 term? Brnovich was, I think we can at least agree, a really seminal voting rights case. It was one of the very few 6-3 splits, if you look at the pattern Erwin led with, implicating Section 2 of the Voting Rights Amendment. The ADL joined 52 other organizations on an amicus brief that was led by the Leadership Conference on Civil and Human Rights, supporting the Ninth Circuit decision. Erwin, doing Brnovich in 6 minutes is not an enviable task, but have at it.
Thank you. The Voting Rights Act of 1965 is one of the most important laws adopted in my lifetime. It did two major things. One, it said that jurisdictions with a history of race discrimination in voting would need to get pre-approval, pre-clearance, before they did a significant change in their election systems. 8 years ago, in 2013, in Shelby County versus Holder, the Supreme Court effectively nullified and ended the pre-clearance procedure. Interestingly, in the Brnovich case, Justice Kagan in her dissent presents statistics about what the effect of Shelby County has been. She said, since 2013, there's been a 2.5% decrease in voting by people of color, reversing what had been a consistent trend in the opposite direction since 1965. The second thing that the Voting Rights Act did is in Section 2. It says that state and local governments cannot have election systems that discriminate against racial minorities or against certain language minorities. In 1980, in City of Mobile versus Bolden, the Supreme Court said that there has to be intentional discrimination in order to violate this. In 1982, Congress passed Voting Rights Act amendments to say that proof of a discriminatory impact be enough to show a violation of the law. That's what Brnovich is about, is whether or not there's sufficient proof of a discriminatory impact against minority voters. It involves two provisions of Arizona law. One said that in order for a vote to be counted, the person would have to cast it in his or her own precinct. The second said that only a person or a relative could turn in an absentee ballot to eliminate so-called ballot harvesting. The Ninth Circuit, in a 7-4 en banc ruling, found that these provisions had a racially discriminatory effect. There's been much more shifts with regard to precincts in minority communities. Statistics show an adverse effect on people of color. Also, in terms of limits in turning absentee ballots, the court found especially this has an adverse effect on Native Americans. As Dahlia said, the Supreme Court, in a 6-3 decision, divided along ideological lines, reversed the Ninth Circuit. Justice Alito wrote the opinion for the court. He said prior cases about Section 2 of the Voting Rights Act involved so-called vote dilution. They were mostly about when redrawing election districts had a racially discriminatory impact. He said, this is the first time we've dealt with time, place, manner restrictions on voting. He said under Section 2 of the Voting Rights Act, it's important to look at the totality of the circumstances. He then identified 5 considerations to be used in determining whether there's a violation of Section 2. First, the extent of the burden imposed on voters. And he stressed that all laws impose some burden on voting. Second, the extent to which the rules depart from practices that were followed in 1982. Why 1982? Well, that's when the Voting Rights Act amendments were adopted. Third, the scale of the racially discriminatory impact. Quite significantly, Justice Alito said, the fact that there's some racially disparate impact isn't enough for a violation. He said, given differences based on race in employment, wealth, education, we can expect that there will be a racially disparate impact to some extent. Fourth, what are the other opportunities provided to vote? The more there are other ways that somebody can vote, the less the court's going to be worried about restrictions. And fifth, what's the strength of the state's interest, especially the state's interest in preventing fraud? Justice Alito was clear that the usual way of approaching disparate impact followed under other statutes isn't here. Justice Kagan wrote a vehement dissent. It's reminiscent to me of Justice Ginsburg's dissent in Shelby County. She pointed out that none of the requirements that Justice Alito points to are part of Section 2 of the Voting Rights Act. She said the court is abandoning its usual approach to racially disparate impact under federal statutes. And she talked about how difficult it would be to show violations of Section 2 in the future. If you look at the 5 factors that Justice Alito pointed to, all make it difficult to prove racial discrimination, all make it very likely that the government is going to prevail. Why does this matter so much? We know that many states, recently Georgia, Florida, Arkansas, have imposed significant restrictions on voting. There's strong evidence that these have a racially discriminatory impact. The Justice Department has already brought a challenge to Georgia's law on this basis. The Supreme Court's decision is going to make it much harder to be able to bring successful challenges to these laws. In our country today, there are 2 very different narratives about voting. The Republican narrative is that voting fraud is a significant problem and that the government has to deal with it. You certainly find that in Justice Alito's majority opinion. The Democratic narrative is that voter suppression is a major problem and that fraud is non-existent or rare. 6 justices were appointed by Republican presidents, and they accepted that Republican narrative. The 3 dissenting justices appointed by Democratic presidents took the Democratic narrative.
And Melissa, you have the unenviable task of adding nuance to that in about 2 minutes, if you would.
So I agree with everything that Erwin has said. I will also note, though, that what Brnovich doesn't make clear is how the Roberts Court has really been quite assertive in shaping the landscape for the law of democracy. So in addition to this decision in 2021, we also have Crawford versus Marion County from 2008, which made it harder to bring constitutional challenges to voting restrictions. We also have Russo versus Common Cause from 2019, where the court concluded that federal courts lack jurisdiction to determine the constitutionality of partisan gerrymandering. And that decision will have considerable consequences for state redistricting process, as we've seen in the last year, and we will see going forward. And then, of course, as Erwin alluded to, Shelby County versus Holder, that 2013 decision, which gutted the preclearance requirements of the Voting Rights Act. And to be very clear, in doing so, in that 5-4 opinion authored by Chief Justice Roberts, the Chief Justice noted that although preclearance was no longer going to be a viable conduit for challenging voting restrictions, Section 2 remained as a viable conduit for litigation against such restrictions. And now the court, in what I think is a very classic Roberts Court two-step, has now hobbled Section 2 of the Voting Rights Act in much the same way it hobbled the preclearance provisions. So again, I think this is a very significant decision. The only other thing I will add is that the court made much of the state's interest in preventing fraud in Brnovich and in the electoral process more generally. There's also another case that was decided on the same day, Americans for Prosperity versus Bonta, where the state of California had issued a provision requiring the disclosure of donors to specific charities on the ground that doing so would help the state in preventing fraud. And there, the interest in preventing fraud was utterly absent from the court's opinion, striking down that California law.
We're now going to do the part of this event that is really tricky, which is a kind of speed round where we offer, as best as we can, kind of compressed assessments of some of the other big cases. Again, with the caveat that we really can't get to everything and that there's a lot that we're not covering. So we're going to just do little 3-4 minute bullets on some of the other big ticket cases that came down. Before we turn to the immigration docket, just a note on language on behalf of the ADL. There are places in US law, including in this year's Supreme Court decisions, where non-US citizens are referred to as, quote, aliens. Although this is the current federal legal terminology, it is dehumanizing and has fallen out of favor among a lot of immigration advocates, where terms such as non-citizen are being adopted instead. Since last year, the current administration is moving to adopt changes in immigration language wherever possible. The head of USCIS, CBP, and ICE have made similar changes, but I just wanted to flag that as a point of some contention in the nomenclature. With that said, Fred, I would invite you to give us a quick walk through Sanchez versus Mayorkas.
Sanchez against Mayorkas is a unanimous opinion by Justice Kagan, 9-0. It's a fairly technical statutory opinion, but it could have a very significant impact on the lives of a lot of people. The court held that an individual who entered the United States unlawfully is not eligible to become a lawful permanent resident, even if he or she had been granted temporary protected status. Technically, whether the conferral of temporary protected status, that TPS status, constitutes an admission into the United States is the issue, because you need to be admitted into the United States to be eligible for consideration for permanent resident status. Petitioners in this case had come to the United States from El Salvador unlawfully in the 1990s. They successfully applied for temporary protected status in 2001. Temporary protected status grants the ability for foreign nationals to stay where they come from a country with unusually dangerous conditions, and it allows them to live and to work in the United States while those conditions exist. 2014, years later, they applied to become legal permanent residents. And the question was had they been admitted, which is what that statute requires, had they been admitted under the temporary protected status law. The unanimous view of the court is that that admission of that, or that grant of status under the temporary protected status law does not constitute an admission. This is a statutory matter, not a constitutional matter. Congress could change this if they wish to. As we look at it today, as many as 400,000 current TPS residents in the United States could be affected by this, because right now they have entered the United States without authorization, cannot seek permanent resident status because they have not technically been admitted.
And Paul, if we think back to Justice Barrett and the confirmation hearings, the Affordable Care Act turned out to be the thing that we were all setting our hair on fire about. It also was one that I think the court decided absolutely not to make a big deal over. Can you walk us through again, a couple of minutes, both California versus Texas, that's the challenge to the Affordable Care Act, the third time at the court, and then take us through Nestle versus Doe.
Happy to do that. I'll start with California against Texas. I think implicit in Dahlia's introduction is the idea that if the court had actually decided the merits of the case, it would have been one of our kind of landmark cases that we discussed in greater length at the beginning of the program. It made the lightning round because the court did not decide the merits and decided the case on standing grounds. And ultimately, the court decided in an opinion by Justice Breyer, joined by most of the court, 7 justices, I think in total, that the plaintiffs in this case did not have standing to challenge the law. The reason for it is a little complicated. I'll try to give it in miniature, which is just basically the issue in the case goes back to the first big challenge to the Affordable Care Act. The court famously, in an opinion by the Chief Justice, saved the law's constitutionality by saying it was a valid exercise of taxing power. Congress in subsequent years did 2 things that I think are relevant here. One, they tried to repeal the statute and didn't have the votes. The second thing they did is they managed to reduce the tax penalty for not complying with the individual mandate to purchase healthcare insurance to 0. And then some clever person came up with the idea, well, if the statute's only constitutional because it is a taxing statute and it no longer raises any taxing revenue, maybe the statute's unconstitutional. It's a clever theory, and at least one lower court judge accepted it. And then suggested that he would go even further and invalidate the whole statute on the basis of that one provision, which struck a lot of people as an odd outcome because Congress had tried to repeal the whole statute and clearly didn't have the votes. I would have expected this case to be decided essentially on those kind of technical severability grounds. So at least personally, I wasn't expecting the court to strike down the statute in toto by any sense. But by not even reaching that issue and deciding it on the basis of standing, the court relegated the case to our lightning round. Second of all, I'm going to talk about this Nestle against Doe case, which is a case that might have been in our lightning round either way, but was another case actually decided on the same day as California against Texas, where the court decided less than most people had expected them to decide and decided it in a less divisive way. So if you're trying to look to Dahlia's one suggested theme that maybe the court managed to avoid some of the most divisive issues in this term, Nestle against Doe would be an example of where the court did do that and decided a case on important grounds, but less controversial grounds than were teed up. This case is one of a number of cases that has arisen in the last couple of years on the court's docket involving an obscure, or at least previously obscure, statute that dates all the way back to the Judiciary Act of 1789, the so-called Alien Tort Statute. They certainly didn't call it non-citizen back then, and it's been with us since 1789. The issue in the case is, to what extent did this statute provide a cause of action to vindicate human rights abuses abroad? And the particular question in the case that was teed up is whether corporations could ever be liable under the statute, specifically domestic corporations. A couple of years ago, the court decided that foreign corporations were not proper defendants under the statute, and Nestle and other large corporations were making the argument that big domestic corporations are also not defendants under the statute. Turns out we still don't know the answer to that because the court said in a pretty case-specific holding that one of its other previous decisions in this area limiting the extraterritorial effect of the statute applied here such that there was no liability. So happy to talk more about it if somebody has a question or answer, but I think this ends up being another one of these cases where the court found essentially a less divisive way out.
Just as we had a huge immigration docket that was compressed into one case by Fred, there was a huge criminal law docket that we are not going to be able to get to in anything close to the fine grain we'd like to, but I'm going to spike it over to Melissa to talk just for, again, a brief time as you can on Jones versus Mississippi. This is return of life without parole for minors.
Right. So Jones versus Mississippi considered the imposition of life sentences for juveniles. Previously, in 2012, the court in Miller versus Alabama determined that outside of extreme cases of permanent incorrigibility, mandatory life sentences without paroles for juvenile offenders violated the Eighth Amendment's prohibition on cruel and unusual punishment. And in 2016's Montgomery versus Louisiana, Miller was made retroactive. In Jones, a juvenile offender who was 15 at the time of his offense challenged his life sentence under both Miller and Montgomery on the ground that the state had not determined that he was permanently incorrigible before imposing a sentence of life without parole. In a 6-3 decision, the court, with all 6 conservative justices in the majority, upheld Jones's life sentence without parole, and the court ruled that states need not make a separate assessment of permanent incorrigibility before imposing life without parole. And I think the bottom line coming out of Jones versus Mississippi is not simply the sort of uneven landscape for juvenile offenders, but the fact that state level criminal justice positions like DA, like state judges, is really important for determining the scope of how the juvenile justice system will be played out and how juvenile offenders will be treated under the system, given the uneven nature of these precedents.
And Erwin, can you walk us through Cedar Point, which is part of, I think, an increasing trend towards making it harder and harder for unions to function?
Yes, the case is Cedar Point Nursery versus Seed. It involves the takings clause of the Constitution, which is the government can take private property for public use, but must pay just compensation. Over time, the Supreme Court has found 2 ways of there being a taking. One, it calls a possessory taking. If the government confiscates or physically occupies property, that's deemed a per se taking. The other kind of taking is a regulatory taking. And here it's where regulation goes too far in the court's words. It becomes a taking and generally requires showing that the government regulation leaves no reasonable, economically viable use of the property. This case involves a California law that requires that agricultural employers allow union organizers access to the property for up to 3 hours a day, 120 days a year. The failure to do so is deemed an unfair labor practice. The question before the court was, is this a possessory taking? In another 6-3 decision along ideological lines, the Supreme Court said yes. Chief Justice Roberts wrote for the conservative majority and said, a key aspect of property rights is the right to exclude others. Even though this isn't a permanent grant of the ability of the unions to come on the property, it still should be regarded as a possessory taking. It's denying the ability to exclude others. Justice Breyer wrote the dissent, joined by Justice Sotomayor and Kagan. He says, this is temporary. More important, he says, this is a regulation. It's not a possessory taking. I think the issue is, what about all the other laws that give government inspectors the ability to go on property for limited periods of time? Why aren't they then possessory per se takings? Chief Justice Roberts says, well, it's different if the government conditions operating a business and letting inspectors be present. But under his analysis, why isn't that still a possessory taking? Or why isn't this the government conditioning operating these agricultural enterprises on allowing the union organizers to be present? As you alluded to, Dahlia, the Roberts Court is very pro-business, it's very pro-property rights, and it's very anti-labor. All of that came together in this case, but I predict it's going to lead to a lot more challenges where there's going to be arguments that giving access to government officials should be regarded as a possessory taking.
And Fred, can you close out the lightning round with just a quick hit on United States versus Cooley, which just implicates tribal police officers and their authority?
United States against Cooley, if you take out the context, sounds like a garden variety Fourth Amendment case. Police officer sees a truck pulled over to the side of the road. He goes over to see if he can help. He has suspicion that there's drugs in the car. Then he has suspicion that the owner of the car may be violent. He pulls his weapon. He does a search. He indeed finds drugs. He finds weapons. What's our question? The question is, the officer is a Native American on a public right-of-way in tribal land, and the individual who was searched, Cooley, is a non-Native American. United States, again, Montana against the United States, 1981 case, said that the tribes do lack inherent sovereign power to exercise criminal jurisdiction over non-tribal members, but they do exercise civil authority over the conduct of non-Indians on fee lands within its reservation when the conduct threatens or has some direct effect on the political integrity, economic security, or the health or welfare of the tribe. So a unanimous opinion by Justice Breyer applies that Montana against the United States doctrine and says, in this case, this tribal officer is permitted on tribal lands to use his authority to search, stop, and seize, in this case, from a non-tribal member. That actually leads to a federal prosecution on firearms and drugs charges.
I'm going to do the second CLE code, and it is O'Connor. No need for an apostrophe. For those who are trying to figure out how to spell O'Connor, it is O-C-O-N-N-O-R. O'Connor, O-C-O-N-N-O-R. And that brings us to, and we're going to pop it in the chat. That's your CLE code. And then we're going to go to Melissa. Erwin said at the beginning that in some sense, whatever way you want to construe this term, it's probably some version of a calm before a storm. And I wonder if you might just take a couple minutes and walk us through what's already docketed for next term, what looks like it might be coming on the docket, and the ways in which the court's effort to tamp down some of the really partisan political issues might detonate as soon as next October.
Sure. So I'm not sure if this is the calm before the storm is the analogy I would use. I kind of prefer the idea of thinking of this term as table setting for the feast that will come in October term 2021. So again, already the court's docket is shaping up for a barn burner of an October 21 term. So on the court's docket is a challenge to concealed carry gun regulations. This is NYSERPA versus Corlett. This case would provide the court with yet another opportunity to expand on its decision from 2008 in DC versus Heller. Heller held that the Second Amendment protects an individual's right to keep and bear arms for traditionally lawful purposes, such as self-defense within the home. NYSERPA versus Corlett offers the court an opportunity to take the Second Amendment outside of the home. And again, the idea would be that there is a constitutional right to carry a weapon outside of the home on your person, concealed, and that is surely within the scope of the Second Amendment. So a much broader interpretation of the Second Amendment and an expansion of the court's logic in Heller. And if the Corlett case is likely to be a flashpoint in the upcoming term, I'm not sure that the conflict between gun rights and gun control regulations really stands as quite as controversial as what will likely be the flashpoint of the term. And that, of course, is the court's decision to take up Dobbs versus Jackson's Women's Health Center, which is a challenge to a Mississippi heartbeat law that prohibits abortion after the 15th week of pregnancy. It will be the first abortion challenge that this newly constituted court, with Amy Coney Barrett replacing Ruth Bader Ginsburg, will hear. Critically, the court's extant abortion jurisprudence, Roe versus Wade and Planned Parenthood versus Casey, prohibit states from banning abortion before viability, which is usually marked at 23 weeks of pregnancy. And that would suggest that the Mississippi law that's challenged here is unconstitutional. Yet, we know that the court considered this petition for a long time. It appeared in conference about 17 times. before the court decided to grant certiorari, making clear that despite the state of the jurisprudence, there is considerable discussion about whether or not to take this case and perhaps some conflict over whether or not to do so. And it will surely be the case to watch next term, as any decision in this case will also implicate the continued longevity of Roe versus Wade. So if abortion rights and gun rights were not enough, the court could also add the hot button issue of affirmative action to its docket for October term 2021. On pending before the court is a cert petition against Harvard University. This is Harvard versus FAIR, Students for Fair Admissions Processes. And that would again present a statutory challenge to the affirmative action policies that are used at many private colleges and universities. The court, of course, could decide to sidestep this in favor of a constitutional challenge that would likely come in the form of a challenge to a public university's use of affirmative action, which also is percolating in the lower federal courts. All of this will be playing out from October 2021 through June of 2022, which is also the eve of the 2022 midterm elections. And I think that is something that may actually constrain the court. The prospect of the court's decisions on these hot button issues becoming fodder for electoral politics may certainly be a concern for some on the court, particularly Chief Justice Roberts, as the term plays out. So if there is going to be a limiting principle, I think the limiting principle will be what happens in electoral politics.
I'm going to turn this back over to Karen, who's going to wrangle the Q&A. There's more than 100 questions in the Q&A, and she's been trying to sort them as we've gone along. With the, just note that you all should continue to put your questions in the Q&A, and we're going to try to take as many of them as we possibly can. Best of luck to you, Karen, getting through 100 questions.
I'll do my best. Let's start with real quick. Could somebody please explain again what the shadow docket is and provide a little more precision on that, because there has been some confusion in the chat. Erwin, I'm going to cold call people.
Sure. Matters come to the Supreme Court sometimes where there is a request for an injunction or a request to overturn an injunction from a lower court. It doesn't come on a grant of certiorari. There's not full briefing of the merits and oral argument. So the cases that Paul mentioned involved instances where religious individuals or entities went to court to challenge and seek injunctions of governor's closure orders. In these particular cases, the lower courts denied the injunctions, and then went to the Supreme Court for the injunction. And so this would be what was referred to as the shadow docket, things that weren't coming on full merits briefing, but nonetheless, the Supreme Court is issuing opinions, and the opinions have the force of law.
Great, thank you. And another common question that we've gotten, and so I'm going to summarize it, is if several of you could share your thoughts on the size and the structure of the court, whether it should be expanded, whether term limits should be imposed. This has been a bit of a hot topic lately, so we've gotten quite a few questions about it. And Dahlia, also feel free to jump in because now you're not moderating. Dahlia, you want to go first? I'm going to keep cold calling if folks don't jump in.
Cold calling, it's very, very in keeping with the CLE stuff. So I think there has been a sort of burgeoning movement to seriously think about court reform. I think that when Mitch McConnell made the decision that already voting had started in the 2020 election, nevertheless was going to put up Amy Coney Barrett, it appeared to be pretty directly contravening the rule he had set out when Merrick Garland did not get a hearing or a vote before the 2016 election. And I think that there was a profound sense on the left that this was no longer about some principle, but just about whoever controls the Senate controls the court. And with that, I think a growing sense, rightly or wrongly, and I'd love to hear Paul's thoughts on this, that the court, the sort of deliberate counter-majoritarian function of the court was now working in a counter-majoritarian way to imperil actual democracy. And so there has been a real, I think, uptick in enthusiasm and interest among progressives to do some kind of structural court reform, whether that is court packing, FDR's landmark failed attempt to add seats to the court. And I should note, people know this, there isn't a magic number. There's nothing in the Constitution that says you need 9 justices, but other kinds of conversations about whether the court should have term limits, whether the court should be subject to some kind of jurisdiction stripping where they can't hear certain kinds of cases. Joe Biden has created a commission to study this and to issue something short of recommendations for what might be done. But my sense of the matter is that this is a conversation that's happening, at least my sense of it, in the margins. I don't think that Biden's court commission, as is evidenced by the conversation they've had so far, is taking at least the court packing piece of this all that seriously.
Sorry, Fred, could you weigh in? Would any one justice, do you think, will have more influence on future decisions if Chief Justice Roberts is now less central to shaping an outcome?
Very hard to make these assessments, as Erwin cautioned us earlier, based on one term and not even a full term of these particular 9. So it's a little hard to know. But there are a couple of observations that I think we can begin to tease out. One is that even within the 6 conservative justices, there are differences. One that we've talked about several times is Chief Justice Roberts is a somewhat more moderate conservative. Probably putting the other 5 in the same category is probably oversimplifying a little bit. It does appear that Justice Kavanaugh is trying to probe for that position in the middle of the court. He's been observed to be the middle of the court ideologically, but it may well be a position that he is very happy to have and to play that kind of a role. In a different way, Justice Kagan might have played that role, but now she's part of the 3, not part of the 6, so a little hard to say. One cautionary note, certainly from some quick commentary that you see, this idea that now we have a court of 3 liberals, 3 conservatives, and 3 sort of in the middle, way oversimplifies the fact that that doesn't make any of that group of 6 we've been talking about anything other than very conservative. We have 3 justices on the court now, referring to Justices Thomas, Alito, and Gorsuch, any one of whom would be the most conservative justice on almost any court for the last 75 years. The other 3 in that group, the Chief Justice and Justices Kavanaugh, at that point, and Justice Barrett, we'll see how they play out, but they are very conservative by any objective measure. Just coming back to Melissa's very good look ahead to next term, we're going to learn a lot about how these justices line up on issues that are much more hot button. So a year from now, ask me the same question, we might have better information.
And turning to Melissa and also Paul, what do we think the precedential value of the COVID-related rulings might be, especially Tandon v. Newsom, in light of Fulton and the way that we thought Tandon would play out in Fulton and the way that it didn't really? Melissa, if you could go first.
I mean, I don't know that we didn't see Tandon play out in Fulton. I think we did not see a maximalist decision in Fulton, but I think you saw the imprint of Tandon in the way the court tried to breach some kind of middle ground between the 2 positions. So, the shadow docket, and this is part of what Erwin said, I mean, these are emergency decisions. They're not supposed to carry the same kind of precedential weight that a decision on the merits docket should have, in part because they aren't argued with the benefit of full briefing and oral argument. But I think we are seeing the shadow docket being translated into the merits docket. I don't know if we're seeing it explicitly, but you can definitely see it in some of the logic of these decisions.
Yeah, and this is Paul. I'll just echo that and say the following, which is, Melissa's right that the shadow docket cases are supposed to be sort of separate. They tend to manifest themselves in relatively short per curiam opinions. So at first blush, they don't have the same kind of precedential weight as a merits decision of the Supreme Court. But in addition to everything that Melissa said explicitly, there's one other implicit point here, which is the court was considering Tandon, for example, at the very same time it was deliberating over the Fulton case, and opinions were presumably going back and forth among the justices on both the per curiam and the merits case simultaneously. So I do think there's a particularly kind of close relationship between these cases in particular. And I think together they point to two potential paths forward for the more conservative justices on the court. One path forward would be to eventually, in a subsequent case, overrule Smith, because you seem to have a kind of working majority of the court that at least has nothing nice to say about the continuing viability of the Smith decision. So they could very well go that route in a subsequent case. But I think these cases together, and I think Erwin may have alluded to this, but sort of do prompt the possibility that it almost may not be necessary to overrule Smith, because if Smith becomes only the rule for those laws of general applicability that are so general that there's no possibility of an exception, well, then all of a sudden, Smith is no longer the general rule. It itself has become the exception. So that's another path forward. And I think we'll see that in the next couple of terms.
So another question that we got different variations of, but quite a few of in the Q&A, and perhaps Erwin, you could address this, is also on the religious freedom, religious liberty, etc. Along those lines, is essentially versions of, if the court seems to be moving further and further towards favoring one's ability to assert one's religious beliefs and sincere religious beliefs in order to obtain exemptions from discrimination, exemptions from other sorts of laws. At some point, does the court become the arbiter of sincerity? And one of the questions used the term ecclesiastic tribunal, which I thought was a fun term, so I'll share it. But at what point do courts have to do this inquiry every single time? At what point are we overburdening the courts? Where do we draw the line? How do we handle this?
It's an excellent question. It's important to remember that Employment Division versus Smith was written by Justice Scalia. And the reason for the rule is, if we give exceptions on account of religion, then we have to define what is religion, and we have to decide, is it a sincerely held religious belief? Employment Division versus Smith said, well, if it's a neutral law of general applicability, you don't get a religious exception. So we avoid having to define what's religion. We avoid having to decide, is it a sincerely held religious belief? The more the court goes down the path, and it's clearly going down this path of giving exceptions for religion, the more inevitably the court's going to decide, what is religion, and is it a sincerely held religious belief? And those are very uncomfortable things to ask the judiciary part of. At some point, aren't making those choices, in essence, establishing religion? The more we give a preference religion over all secular beliefs, doesn't that run in tension with the Establishment Clause? So I think the questioner is absolutely right, and that's clearly the path the court's going down.
And finally, to again sort of summarize and consolidate several questions we've received, is there's this notion that, ideally the Supreme Court shouldn't be ideological, but I think we all know that that's sort of not the reality. What possibility is there, or what indications are there of perhaps the conservative justices, as you alluded, not lining up the way that we might have expected? Or is there some folks have suggested, might there be potential changes? Might they drift left? Might they drift further right? What could we potentially expect? This one's an open round to anyone who wants to weigh in. I think this is going to be our last question as well, looking at the time.
I think what we can expect is a very conservative Supreme Court that's going to issue some very significantly conservative decisions in the next term. I could obviously be wrong about that, but I think this was the term that just concluded where the court might have tried to trim its sails somewhat, coming off of two bruising confirmation hearings, but that's now behind us. They move into another year. The court cases that they've decided to take for next term do not look like a court that's looking to trim its sails. So to keep the metaphor going, I think we are sailing into choppy waters, and I think you will have a very conservative court issuing very conservative decisions on some very significant issues for the body politic.
All right, anyone else? All right, Dahlia, I'm going to send it over to you to wrap up. Thank you all so much.
So I think I want to start just by thanking the ADL for the phenomenal work it does. And as I suggested at the beginning, please have a look at the materials, because it'll give you a better sense of what they've been focused on in a really, really busy term. And I want to thank the National Constitution Center, which just does yeoman's work to put the Constitution at top of mind for a lot of people, including my little kids, when they used to go on school trips and suddenly knew more about the Constitution than I did. So really important work now more than ever. I opened with this framing question, which we've been batting around a little bit about, was this a 6-3 court? Was it a 3-3-3 court? Was it a 2-2-3-2 court? You could do this all day and all night. And the answer to all of those questions is yes. I think that there is one story that Justice Breyer likes to tell, which is that this is a 9-0 court or an 8-1 court made up of people who are just kind of brains in vats, who have no ideologies or political predilections. That's probably, I think, been belied by this term. The last thing I'll say is that we didn't talk a lot about the single most important, in my view, fact of the term, which is that the court, despite many temptations and invitations, didn't wade into the 2020 presidential election. That if we, going into this term, had polled ourselves, we might have expected much more intervention from the Supreme Court, and certainly lots and lots of dicta and lots of early ideas about how the election was going to run that suggested that the court might be prepared to intervene in that election. I think just going to what Erwin said about Brnovich, it's easier to intervene in ways that are very, very occluded by technical jargon than to just jump in the middle of election. And it does seem as though the court, at least in Brnovich, I think moved the goalposts, but in ways that are much less dramatic than we might have seen in 2020 around the election. But I do think that the goalposts have shifted. I want to thank Fred Lawrence, Paul Clement, Erwin Chemerinsky, Melissa Murray, and as I said, the amazing folks both at the Constitution Center and at the ADL. I want to thank all of you for tuning in. And as everybody has said, hopefully next year in Philadelphia. Thank you so much for being with us.